Good evening, viewers, and welcome to The Lifeline on Equa TV Africa, a program that x-rays legal issues as they impact society. This evening, we are going to be looking at the Supreme Court in recent days. You will recall that if you have been following the news, that a few days ago, the Supreme Court passed a decision that says lawyers could wear hijab to the court, and that is their fundamental right. That's the right to freedom of conscience, thought, and religion. So it's an expression of their religious belief to wear hijab to court, and to school. And that has generated a lot of issues. A certain lawyer wore his wig and gown to court, and there were feathers on the wig and gown, on his wig, and he made a white mark around his right eye, and also wore a red tie that was like a wrap attire, and we barefoot and entered the Supreme Court. And the justices of the Supreme Court looked at each other and said the court will rise. And that generated a lot of issues, and it's still in the news. Then, before that could be digested, the Supreme Court of Nigeria, that is the leader of the third arm of government in Nigeria, decided to resign on medical grounds. But before then, there was a petition by the 14 justices of the Supreme Court, his colleagues, whom he is the leader, who wrote complaining about the way things were going, the welfare of judicial officers and stuff. And that became very difficult to isolate the petition and the head grounds upon which he decided to resign his appointment as the Chief Justice of Nigeria. And the same day, another Chief Justice of Nigeria was sworn in to take over, Justice Ariwola, who took over from him as the Chief Justice of Nigeria. And tonight, we'll be looking at these issues. What are the issues? What is the impact of these issues on fundamental freedoms? What is the impact of these issues on the administration of justice generally? And to me, in the studio to discuss this topic is a regular face. He's a regular face on this program, Barrister Matthew Godfrey. Barrister Matthew Godfrey is a just-based legal practitioner and a leader of the Christian Lawyers Fellowship of Nigeria Just Chapter or Just Branch. So he will be doing justice to this issue. First of all, Barrister Matthew, the decision of the Supreme Court on the use of hijab in schools, how do you look at this? How does that affect human rights, the enjoyment of human rights in Nigeria?
Well, Steve, first of all, I will look at it differently from the way a layman will look at it. Objectively, I will respect that judgment as a valid judgment of a court of competent jurisdiction. So I will agree with that judgment from professional angle. Secondly, the import of that judgment and its effects on realization of human rights in Nigeria will further stultify the cause of justice, public order, and decency. Why am I saying this? Because if the judgment of the Supreme Court empowers Muslims to use hijab to appear in public school, it clearly means that it has set a pace for other religious belief or other people with freedom of thought to also seek, by interpretation, to also follow suit in a public appearance by wearing the regalia that identify them with their culture, with their religion, or with their worldview, whether freedom of thought, conscience, or religion. So the import of that judgment also is a license for all Nigerians who fall under Section 38 that talks about freedom of thought, religion, and conscience to appear in the regalia that their religious belief equally prohibits. The essence is that that judgment is not only applying to the Muslim faithful, because if you take it to the Muslim faithful, it could equally mean that abiding by that decision alone is against the principle of Section 42 of the Constitution, which prohibits discrimination on whatever ground. So if the law says that Muslims can approach the court, can approach public places, schools, in their traditional regalia, in their religious regalia, on their religious outfit, it equally implies by cause and effect interpretation that also the people that are in Aladora will go to court, will go to school in their own regalia. The people that worship Sango or other religions will go to school. So the import of that judgment, in my own take, is creating a sense of anticipated public disorder that we will have in Nigeria, because it will make secular institution to lose its essence. It will make public institution also to be infested by different religious and maybe cultural perspective, and this will affect the fabric of secularity and even public order in Nigeria.
Well, but you know, when you started, you say you respect that judgment. It is a valid judgment, and you agree with it. But now, from what you have said, it doesn't show that agreement. Normally, as lawyers, what they do is that when a decision is delivered, when a judgment is delivered, a lawyer will say, as the court pleases, whether he agrees with the judgment or not, whether he agrees with the reasoning of the judge or not. Then when he goes on appeal, the same lawyer who said, as the court pleases, will now say, and then in fact he will go forward to thank the court for the well-considered judgment, or for the industry putting in writing the judgment. And then when he goes on appeal, he will now say, the court erred in law, and then begin to point out the errors of the court. When you say you respect the judgment, it is valid, yes. No lawyer is expected to say a judgment of a competent court, of a court of competent jurisdiction is not valid. It is valid until set aside whether it is right or wrong. So now, do you agree with that judgment as being a good judgment to develop society?
Now, when I say that I agree with that judgment, I say professionally, and you have highlighted what it means for a lawyer to agree with a judgment professionally. Because whether you agree with it or not, it's not going to change the substance and the position of that in law. All you need to do is, if you are a party, in that case you exercise appeal and appellate jurisdictions, and also you explore other options, maybe public criticism, awareness, and as time unveiled, that judgment may likely be turned aside. Now, why am I making a clarification further? No matter my sentiment, no matter my passion or dispassion, I have to respect that judgment, because it's a judgment of the Supreme Court based on the hierarchy of the laws. But if you are looking at it about its impacts on the society, how will that law develop the law? The court has said in series of cases that the Supreme Court can err, and the fact that Supreme Court has erred, it does not make that Supreme Court infallible. Supreme Court is fallible, is infallible because it is final. Now, that is why as a lawyer, you respect that view. But coming to look at it also in the wind of time, you criticize that judgment, you help through public sensitization like this medium to point out where the judgment is lacking, how it will impact on the society, how if that judgment continues to be a judicial precedent, this is what it will cause. Now, that will address a part of the question as to what is the import of that judgment to Nigeria's jurisprudence. The import of that judgment to Nigeria's jurisprudence, like I said earlier on, is now saying that by the rendition of that judgment, it means a Christian will go to a public school with his attire the way he wants it. It means a traditional worshipper will go to a particular public institution with the way he is dressed in worship of his god or goddess. Now, this will affect public order, which is one of the conditions for denigrating any other right under the 1999 Constitution, specifically Section 45. So one said that every other right mentioned in certain aspect of the Constitution, including freedom of religion, is subject to public order. That judgment was given in contrast of public order and public policy. Public policy enhanced that things that should be done must tally with the public interest in terms of what? Utilitarian value. Utilitarian value means that that thing must be common to all people. Is the use of hijab in all institutions by Muslim people, is it common to all Nigerians? If you say you feel in your wisdom as Supreme Court that this is common, then it have left a floodgate for other people to now start using their traditional regalia to appear in public institutions. And I think that was perhaps what inspired Chief Omori to come to Supreme Court in his traditional affair. And by the looking of that, by his attire, Supreme Court have no any other option than to call for recess. And so you can see the import. This is a graphic and practical demonstration of what the import of that judgment will portray to the society. And the Supreme Court has said itself in several authorities that there are instances that they can overrule themselves. For example, when the judgment is given per incurium, that is given in error, when the judgment is also delivered, okay, without the jurisdiction of the court, when the judgment is delivered in such a way that it will lead to practical injustice against the other parties, and when the judgment is equally interpreted in such a way that it will go against public policy, these are the grounds that Supreme Court may reverse itself. And so the Supreme Court in its statutes, not only as an appellate arbiter of Nigerian jurisprudence, but it is also a court of public policy. So it has another opportunity now to reverse itself, to look at if we allow this judicial precedent to go on, it will not proceed. Let me give you the position of the Supreme Court in the 1968 decision. In 1968, in the case of Ojeginde versus Odembe, what happened in that case was that prior to the 1967 election that was conducted by them, there was a protest by somebody, Ojeginde, from Imo State, an Adventist. He said that, no, you cannot condone election on Saturday. It is against my freedom of religion. It is hindering, it is impeaching on my right to freedom of religion. And the court went on from High Court, Federal Court of Appeal, and then the Supreme Court. The Supreme Court held that no, that in instances like this, your right to freedom of religion not to participate in federal election of 1967 because it was conducted on Saturday is inferior to the overriding general interests of the land. Because if the reasoning of the Supreme Court by then was that if we allow you now on Saturday to cancel the election and say that it deprives you as an Adventist of your fundamental right, the question now is that there are also people who are traditional worshippers that maybe their worship day is on Monday. There may be another one whose worship day is on Tuesday. There may be another one Wednesday, Thursday, Friday. You can't lack people with freedom of conscience, religion, that in all of the 7 days of the week that they don't practice their religion. So if we give you that religion now, everybody now come with that same measurement of the interpretation. It means that the whole of the week will be declared public holiday. And the Supreme Court turned that decision. Now we are expecting that the same will have happened. Equally, in the 1990s, there was a decision involving Goza local government area and Adamu versus Goza local government. The issue has to do with whether the same issue of hijab and Muslim studying in Christian institution should be allowed to study under certain consideration. But the court was able to uphold that no. The issue here is that you have to look at the right to education is not justiciable, and so the issue that has to do with the freedom of religion conflicting with education, that cannot be done. Now you see it here, we're expecting that if the doctrine of stare decisis, which is built on judicial precedent, should be something to develop upon, this will have been a 21st century opportunity to nail to hit the nail on the coffin and close this case once and for all. But now they are going somersaulting on the previous precedent that was set to settle this matter. So by doing this now, they have opened a canker for a lot of protestation and contestation. I am telling you, this is just a few we have seen. Remember, schools are on strike now. The universities are on strike, the polytechnics are on strike. By the import of that, I am telling you, if nothing is done, sometime the lecturers may find it difficult to come and stand in the class, because some people will decide to say, may, God forbid, say that in their freedom of religion, in their religion practice, they don't wear complete dresses. So they will come and stand before lecturers because Supreme Court has given that verdict. Some people may likely come with snake on their neck and say it is their freedom of religion, that they are a Krishna and snake is part of their deity. Some people may decide to come with lion for Ortega, for all those things. You can expect it. So it is an opportunity for the Supreme Court to look itself into it and say that we need to revisit that if we want Nigeria to continue as a nation where peace, unity, and progress and tolerance shall proceed. Tolerance is part of our national ethics, where we want to exhibit certain things that want to portray one religion or one worldview as dominant over the others. We are not helping in progressing as Nigeria. Is the issue of hijab more central to the realization of fundamental rights? The proponent of hijab that are talking are the people that educationally are the most backward, are the people that are victims of insecurity, are the people that are victims of poverty, are the people that by all index are in the negative. So is that the gifts that Supreme Court will give, and people will be happy that they are found? Africans are so conscientious, are so conscious of the ideal, and they forget the reality of what benefit could it be for me if you say my religion as my denomination, let's say as an equal Catholic cooking, is given the right to enter everywhere with rosary and this thing. Then my people, the reality from where I come from is the most on the planet, is the most insecure, is the most backward. Why can't the Supreme Court? There are many cases that Supreme Court ought to look at it to impact on the economy, to impact. They have not done it. Why interested in this one? And so I think these are some of the issues that I think are very, very unfortunate with the impact that this decision may have created.
So in essence, you are advocating the Supreme Court overruling itself.
Of course.
In this,
of course.
So how will that come to be? What is the procedure for the Supreme Court overruling itself?
In a situation like this, a matter may come in a similar manner, whereby that decision may be cited. And once it is cited, a good advocacy will convince the mind of the Supreme Court justices to see that relying on this precedent will orchestrate injustice, abuse of public order and decency, and also abuse of public property. In his judgment, majority of the leaders of the justices of Supreme Court may decide that based on this convincing advocacy, we are persuaded that sustaining this particular authority can affect public order, can affect public policy, can also affect decency, and such it is no longer applicable. This is one step of neutralizing the potency of that judicial precedent. Another one is where a particular case of a similar fact may likely rise. If you come by the importance of that judgment, if you bring it in another case, another person may decide to challenge it in another different view. If the matter was introduced through OS, another person may likely bring it through writ of summons to challenge different procedures. If it comes, whatever it is, if the court dismiss it, they go on appeal. If it's sustained, gradually, one way or the other, the Supreme Court may have another opportunity to revisit itself. Let me tell you, it's not only in this area. We are going to talk about the next input and the contribution of the retired CJN to Nigerian jurisprudence? How has it helped the system, or how has it marred the system?
Okay. Now, can a body like the Nigerian Bar Association, can they apply to the Supreme Court that this decision is capable of, or is already throwing the country into disorder and anarchy? Can a body like that apply for leave to make an application that the Supreme Court should overrule itself?
I am not conversant with that law, and I think I would like my betters to put me through if there is a position like that. But one thing I know is that they can only write, communicate, and petition that reliance, the import of this decision will cause so and so. But as far as the law is concerned, their writing cannot overturn the decision.
No. I mean,
I know.
Okay, yeah.
Yes, I know. Their writing cannot overturn the decision. The decision is already decisive. That's why we say stare decisis.
Yes.
All they can do is persuasive approach, then campaign, and see how another opportunity will come for Supreme Court to overrule itself. That was what I told you initially, that I have no any other option than to agree with the decision professionally, because as a lawyer, no matter how bad a judgment is, you are bound to obey it until set aside by a court of superior jurisdiction. So this is what the NBA will do. But in the course of time, public policy, public analysis, public commentary, academics can go into writing, challenging the import of that. Researchers can go into legal research, looking at how that will apply. Then sociologists also will now look at the import, look at it, a good sociological discourse in this case, from the way Omoribo apply. How I wish ASU is not on strike. You will see the reflection. And as I am talking to you now, in this reflection, in certain areas now, the beneficiaries of this judgment may not allow other people to exhibit the same freedom, using their culture in their own region. This will bring a problem. So you now see that is why in the 1960s case of Ejeng versus Odende, the court took to say that no, Adventists, we will not rule that holding election on Sabbath is a violation of your fundamental right. Because if we do that, there are some people that are worshiping Sango will come on Monday, will come on Tuesday. So the whole day will be a public holiday, because it will be a day for respect of fundamental right, and there will be no secular activities. This is the path that Supreme Court ought to have followed. But we don't see them doing that, and we wonder, are we in the era of judicial activism or judicial regressism?
Well, and by the way, oftentimes you find that elections spill into Sunday.
Yes, elections spill into Sunday, and the adherents of Sunday as a worship day tolerate the secular system. They condone it. Yes. They say, let it be done. It doesn't affect the integrity of our faith and the substance of our creed or the substance of our religion. Yes. So that thing doesn't. But the issue of bringing those things here, I think, is really, really a blow to the freedom of civil liberty in Nigeria. Okay.
Now, we'll move on to the resignation of the Chief Justice of Nigeria, Justice Tanko Ibrahim Muhammad. Now, this came as a shock to many Nigerians. They were not expecting. Of course, there was no news of the CJM being down with any ailment of some sort. And then suddenly he came. But just before his resignation, there was this complaint by his colleague justices of the Supreme Court, who wrote, 14 of them wrote complaining about issues that he was in charge, including the welfare of the justices. What do you have to say about the resignation of the CJN?
I think the resignation of CJN is a welcome development. But let me say this. The issue of the ill health of CJN was a product, why it was not disclosed publicly, was a product of good information management by those that are around. But people that are closer were able to say that there are instances that exhibited that old age is there. Now, you should also know that the controversial circumstances under which he came into power is maybe the nemesis of what is playing out. The issue that has to do with his resignation and ill health, on ground of ill health, has been there. The notion, the recent petition by his colleague, I think Nigerians should also learn to be sensitive that they should have seen that coming when Justice Eko was retiring, and in his retirement speech made a public confession that the salaries of the justices of the Supreme Court has not elevated or increased from over 2011, since 2011 to now. So this got to tell you that these people are social animals in this system. They face inflation. They face the impact of the poor economy. You have done nothing to protect their interests. And they allege that certain billions were unaccounted for, specifically in the petition, making mention of the fact that the CJN and his family have access to overseas vacation, while they don't even have their own entitlement. So you can see that, and quite unfortunately, I stand to be corrected by those who were called to bar before me. This should have been the first, if not the first instance, whereby justices of the Supreme Court are petitioning their head. And if they are doing so, it clearly shows you that there's something wrong with the head. And like the Yorubas will say in their proverb, that if a fish starts getting rotten, it starts from the head. So you find out that what happened is a clear situation of a decrepit judiciary we are having in Nigeria. The dysfunctional leadership of the CJN that may have led to this lack of information management and crisis management among the justice of the Supreme Court to write is clearly show that something is wrong. And you can see the reflection from the process of the appointment of justices to the Supreme Court, from the lower bench to the higher bench, all the processes. So you can see that there's something that is wrong. And so his resignation on a health ground is a good one. And the question I keep asking people is, have we in Nigeria, in our integrity index, we should improve? The justice of the Supreme Court, if there are any medical report showing when that sickness started, some people are alleging that it started 2020, some people are alleging that it started 2021, late 2021 up to now. But the question there is that if he has been having this sickness and medical report is there and he presided over certain judgment, that judgment will have been time to be given by incursion because the issue of the competence is not there. The case related to him, if it has to do with the issue of health ground, maybe if to say it is something that's to do with incapacity of the mind, you know that somebody that has that ailment is a flaw to the composition of the jurisdiction of the court, is a deficit to the composition of the jurisdiction of the court. So a question that you can ask retroactively, maybe for analysis, is that, assuming he's presided over 7 cases, 8 cases, you ask yourself, during the proceeding of that case that he presided, was he in the right frame of mind? And this is something that we may not answer in Nigeria, but only God can answer. So these are some of the issues. And ideally, if these deficits are cleared out, that means that all those judgments are given by incursion because the composition of the judge, one of them is not well given that judgment. So I think these are some of the issues that goes with the resignation that need to be addressed.
How do you appraise the tenure of the immediate past Chief Justice of Nigeria?
Yes.
How has he impacted the judiciary?
Yes, I can, with all sense of fairness, I can give him maybe 50-50 in the little while he came. I was not personally happy with the process that led to his emergence as the CJN of Nigeria. And that's why I'm now saying that his resignation on ground of ill health should not be an immunity from investigation and prosecution. We are calling on the anti-graft agencies, the other security agencies, to now see that this case is properly probed and investigated. Ill health should not be an excuse for lack of accountability. We will sympathize with him on moral ground, but let the law do its course to find out how that thing will be addressed. Secondly, the question you said, he was able to make influence certain decision that is very progressive to the development of the law. For example, the decision, overturning certain political heavyweights, settling cases, defection of political parties from one party to another. He was able to encourage the judges to be bold and declare politicians that have cross-carpeted from legislature their seat vacant. That's a bold step. Then talk about others also, stating the law as it is. But there are about 2 or 3 that I have problem with. One is the precedent in Abubakar versus INEC, where the issue of whether Muhammad T. Buhari is the same thing as Muhammad Buhari. The court says that there's nothing wrong with that judgment because the name is not of a fundamental defect. But the same Supreme Court, in the case involving a senator in Adamawa, whose name was fundamentally defective in terms of just a change of one surname with a particular initial, the Supreme Court said that it was wrong. So there was no flaw or logic behind the consistency behind the decision of that principle. Now you also look at it, like some of my friends, they'll call me and say, all they need to do now to say by the import of the judgment in Atiku versus Buhari. He say all he needs to do is that he will not go to university, he will go to court and deposit on affidavit that he has been to university, and so that affidavit will stand as a certificate. Now, this is the position. The other negative effect of the decision that you will now look at is the issue of the hijab we are talking about. The issue of allowing hijab. While as a Sufi, he knows better than I, and I know they know better than I do. I wasn't born at that time. I came, I made that judgment. Ojegbede versus Yankee. 7 days Adventists were overruled that we are not going to cancel election or to say that election has violated your right because it was on Saturday. We expect same principle to be applied here. But when you uphold a particular religion and say this will be done, this is a judgment that France refused to uphold that judgment. India refused to uphold that judgment. Nigeria is now creating, and it is quite unfortunate because Nigeria is more pluralistic, if not India. But other Western questions that turn against this question, Nigeria is more pluralistic than them. So once you do that, as I'm talking to you, you will see this judgment, if care is not taken, will set a ground for civil disturbances in this country.
Well, we'll go on break. When we resume, the phone lines will be open, so you could call and ask questions and make contributions. So we'll go on break. Welcome back. We will continue. The Barrister Matthew was looking at the contributions of the immediate past CJN, Justice Tanko Muhammad, to the Nigerian jurisprudence. Barrister, what else do you have to say about the contributions of the immediate past CJN? But before then, don't forget you can call to make contributions or ask questions. The phone lines will be displayed on the screen.
Yes, some of the innovation that happened under him can give it to him. The proactive approach to virtual hearing, the issue of during COVID-19, whether Nigeria will imbibe virtual hearing or not. I remember there was a hot debate, and one of the proponents that is of the opinion that it violates Section 36 of the Constitution, which says that hearing must be public. But in the case of Ekiti versus Lagos State, even though it was struck out, the court was able to say that virtual hearing will be deemed as conforming with the provision of public hearing. Now, you also can give that to him. There are also some of the reforms that he made. For example, the encouragement of appointment of judges, and in sanitizing the political system. He made mention discouraging judges from issuing conflicting orders, and also the issue of using ex parte to stultify a legally achievable process or implementation. That was what MBA had to come. I remember I met him and met with him to discuss the frequency, the abuse of the frequent conflicting judgment. And I think he did that by sanctioning some judges, and that has reduced the proclivity of conflicting judgment. And these are some of the reforms that you can accredit to him, that he did well in that regard. And also, I noticed that he tried the best he could to liaise with NBA, Nigerian Bar Association, in the promotion of rule of law, and to encourage the public that judiciary is still the hope of a common man. But these are wishes that did not translate into reality during his tenure.
Well, you mentioned the issue of people making jests that you can, instead of going to the university, you simply depose to affidavit that you have a degree certificate.
Yeah.
And just now, there's a live issue in the APC candidate, Bola Ahmed Tinubu, who has also deposed to affidavit that he has 2 degree certificates, and that none of them is there. They were taken away by soldiers or so.
Yes, in fact, you must. We need to understand the electoral jurisprudence before condemning Tinubu. If you look at under the Electoral Act, false information is one of the grounds upon which an election can be nullified.
Yes.
Now, under the 2022, false information is no longer a ground.
Yes.
Now, even the one in 2010, the Supreme Court, in a decision, has interpreted that to mean, in the case of INEC versus Buhari, that even if you have any certificate that is equivalent, or even if your name is MT or MD, the slight difference is not fundamental. That is on itself is an added strength to people like Tinubu. The issue now is that whether he presented his certificate or not, it is the INEC that will now determine. We have the right to disqualify him because he has not qualified. Where he failed to do so, people can challenge that in court as a pre-election matter. But happily for him, his certificate from Chicago has come out. Now, with all sense of objectivity, I don't want to criticize Tinubu unduly. Anybody that knows the history of Nigeria will know the contribution of Ahmed Bola Tinubu in championing the vanguard for democracy through the institution of NADECO. He was one of the people that are wanted by Abacha men in those days. So, to an extent that history has it that he sneaked into Lagos, disguising as a woman to have a meeting, and then go back to Benin Republic. So, he and Wole Soyinka and others were being hunted by military men. So, I am not holding brief for him, but there's a plausibility that really something will happen with his primary or secondary school certificate. But we should go beyond that. My concern with that is, do you have people that are his classmates? During President Buhari's, they were shopping for his classmates, but incidentally, all of them, whether like there was one body. I saw a picture viral on social media, somebody identifying with him in secondary school. Let me tell Nigerians, I like Peter Obi's approach and his supporters. don't go into personality attack. Attack Tinubu on what are his practical solution to Nigeria's problem. What are his practical solution? Because all this one, many of us who can cast a first stone, I know many Nigerians don't have their primary school certificate. Many, as I'm talking to you, get about 10, 20 Nigerians. Do a sample test of where is your primary school certificate. Some people will tell you that maybe during crisis it was born, just like Tinubu's purported one seized by Nigerian army. Some people will tell you that they lost it. Some people, so you will have different rendition. Let's pass beyond that.
Some
level.
people didn't collect it.
Some people didn't collect it. And some people will tell you that the location of the school is no longer there. So a lot of these things. Let's look at him and ask him, what do you have to offer to Nigerians better than Atiku, better than Peter Obi? That should be a more engaging confrontation and good one for us.
No, but in any case, if there's a requirement for contesting election, shouldn't somebody who is coming to contest meet that requirement?
The stipulation of the requirement are there. Where there are certain types of requirement, there's a prescriptive requirement, there's a mandatory requirement. The mandatory requirement, the court held in the litany of cases that for non-compliance with any requirement for election to have validity and effect, it must arise from the one that is provided for in the Constitution.
Yeah.
Now, any non-compliance that is not provided in the Constitution is a defect. And I can tell you categorically, issue of primary school certificate, I don't think it's in the Constitution, but we have the secondary school certificate or its equivalent. That was where the court now, instead of strengthening that decision, in the case of Buhari, went and said that its equivalent could mean even an alternative. So you just see, and the Supreme Court was right. So this is it that I'm telling you, you are talking of Tinubu's primary certificate, look for all that thing to address him. His secondary and school, if he has a good distance, it happens. And to be honest with you, I'm not a supporter. I'm not a supporter of, I'm not holding brief for any political party, but I'm speaking with an empathy and dispassionate mind that if maybe Peter Obi has the same case, this is what I will say. If Atiku has the same issue situation, this is what I will say. And this is what the law is.
Yes. So now back to the Supreme Court and the CJN. Now another CJN has been sworn in, and that CJN is gone. What do you think should be the things that the first priority of issues that the new CJN should address?
Yes, the tasks before the new CJN now are enormous. Jurisprudentially, in terms of the legal philosophy, he has to see how some of these decisions that are against national interest and unity should be challenged. Should try to see how decisions that are anti-democratic should be addressed. Issues that has to do with the decision in Uzodinma case, issues that has to do with the decision in the hijab case, issues that have to do with the decision in Abubakar versus INEC. Some of these, through judicial activism, the Supreme Court can now revisit itself and then overrule itself on those issues when the opportunity arrives. Then the issue of the petition of his predecessor should equally be what? Be addressed. Because the issue now is that the best way to clean himself is to set a panel, to liaise with the anti-graft agency, to set a panel. Why was Tanko not able to account for that money that was given to the judiciary? Now, he should do that. He should also try to see how he can address the paucity, the decrepit situation of Nigerian judiciary. I'm saying this because let it not only be an elitist revolution with respect to the Supreme Court, Court of Appeal, and then Federal High Court, National, and then the High Court. Let the revolution or the reformation affect even the lower courts. Let him see how he can sanitize the system with respect to competency, integrity, of the judiciary, with respect to appointment, with respect to promotions, with respect to to the issue of dispassionate dispensation of justice. Let him also address the poor welfare packages of the lower court judges. I can tell you categorically, I was in court the other day, we could not proceed with the case. Why? Because the judge said that his record book is finished. This is a case that we adjourned from March this year to be heard just on the 22nd of this month. Now, all that happened was that we went to court on the 22nd of this month. After the judge was taking the note, he just looked at the civil record book and he drew our attention to say that I cannot continue because I don't have sufficient notebook to care. The impact of that day on the person that is supposed to be granted bail. What is the impact on the case, on the litigant that have wasted their money? There are certain costs, lower bench court that you go, the proceedings will not take place because it rained. And the court will tell you that it will not see because it is raining. The books will get soaked and the judge himself will get soaked. These are the issues that they will address. Until you start addressing the issue at the lower level, the politicians will have a way of dividing and ruling you. The welfare of the magistrates all over the country, maybe, except some few states. Lagos are trying and some other states. In the north, in the south, what about their promotion? What about go and see what perquisite of office do they have that you can say that this person will be independent from corruption? You are already putting a person in a frying pan and you are saying that he should feel as if he's in a deep freezer and should feel relaxed and cool. No, he must act to the response. He must act to the response of the reality of time. They are in the society where inflation is high. Politicians are their neighbors. And so you think that if one way or the other, politicians cannot influence them. I know of a judge, I was going to a court one day, I saw her even boarding a car to go. We know of the high court judge, lower court judges that you see a situation, you can empathize with them. The law says do not give them something. Giving them something is prohibited as a lawyer. But something will be telling you in your mind that this man needs something. You can see it in the body language. So they must address that because this is a channel that people will go. There are certain judges that started from the magistrate up to maybe the Court of Appeal and the Supreme Court before they retire. So he should not only look at the Supreme Court, Court of Appeal, National Industrial or Federal High Court or State High Court. He should look at all the arms of judiciary. How can he address that? How can he engage a dispensation of criminal justice system? How can he actualize he can help in facilitating quick dispensation of justice? These are some of the issues that lies before him. How can he also address the Jusun strike that is going on? These are some of the things that lies ahead of him. And we ask God to give him wisdom to dispense such a vision that lies ahead of him. He has to cleanse the system because his predecessor has left some mods that have deadened the flow. So you need to wipe them off.
Well, listeners, this is where we draw the curtain. But before then, Barrister Matthew, what are your final words?
My final word is the recent days of Supreme Courts are not been pleasant to Nigeria. Legally, the legal minds are not in all force with them because their verdict has not reflected the justice in terms of equity. And the resignation of CJN is not a welcome development for Nigerians either because it's not only on ill-health ground, there was a petition of financial inaccountability. So these are the issues that have been. So for the incoming CJN, he has a task to right these wrongs.
Viewers, this is where we call it a day for today. Do keep a date with us, same time, same station, next Wednesday, and you will not regret you do. Thank you and have a lovely evening.